Judge Chutkan issues scheduling order. Welcome to Law and Society. Please subscribe and let's briefly go over the scheduling order. As I talked about in the previous video about the status report, I said that Judge Chutkan would not accept the extended schedule that Donald Trump had proposed. That she would be more expedient about it, and we see now that that's what Judge Chutkan has done. First thing that she does is saying that all of the pretrial motions and deadlines are to be stayed, except for the ones that Judge Chutkan orders for the pretrial schedule at the moment. So the first thing Judge Chutkan to wants the government to do is to disclose any evidence and mandatory evidence under the Brady Rule, essentially saying if the government has any exculpatory evidence, any evidence that would vindicate Donald Trump, they have to turn it over to the defense. So then there's then Donald Trump would have to reply, and then in the reply has to point out specific evidence related to presidential immunity that Donald Trump claims that the government has improperly withheld, if there are any. At that point, that goes into September, the late end of September. Then the government will file its opening brief in the presidential immunity issue by September 26th. So the date to watch for the public is September 26th, when the government files its opening brief in the government's immunity issue. This is one of the issues that has to be adjudicated before any other motions are considered. So that's a key date. And then Donald will reply to that on October 17th. And then government will reply to that on October 29th. And then there will be a hearing. And then the court will decide what to do with uh, with the immunity motion. Then supplementally and concurrently, so Judge Chutkan listens to the government's recommendation of moving in the same time. Uh, Judge Chutkan has ordered that the defendant would also file during this time of, uh, you know, filing of the opening brief of immunity and the reply and all of that. That's along the same time. Defendant Donald Trump would have to provide for the motion to dismiss on statutory grounds, and also the dismissal based on the fact that they claim that Jack Smith is not authorized or properly appointed to handle this case. So we have here a schedule that has been laid out, and the deadline, the last date, which is for the government's opposition for the government, the defendants replied to the government's opposition on the dismissal of the appointments issue. Because so we know that before that happens, Judge Chutkan says that after briefing of the immunity issue, the court will determine whether further proceedings are necessary. So that's the hurdle that they have to cross first in order to follow the Supreme Court's command. And it's a pretty the last due date for defendant's reply for the motion for whether Jack Smith is improperly appointed or not is November 7th, 2 days after the election. We heard from Judge Chutkan during the oral arguments that she is not going to conflate the legal calendar with the political calendar, that she's not going to bring in any election considerations when she's setting her schedule now that it has been over a year late. Defendant Donald Trump's lawyer also wanted to really have the appointment issue and the issue of uh, um, other uh, other considerations to be brought up before the immunity issue. Judge Chutkan doesn't do that. She essentially says we're going to run through this concurrently. And uh, during the oral arguments, there was a point where Lauro said that in terms of the immunity hearing, just the fact that they even put Vice President Pence's interactions with Donald Trump, that was told by SCOTUS to be immune. Judge Chutkan corrects the defendant's lawyer, I believe it was Lauro, saying that no, that was a presumption of immunity, and that's what the court is doing here because the Supreme Court sent it back to Judge Chutkan's court to determine whether the government can overcome the presumption of immunity in the instances that are brought up to be acts where there would be some level of immunity. So there is all these considerations that's crunched from now to November 7th, and we're going to see the government's case on September 26th. We're going to see Donald Trump's reply to it. We're going to possibly even have a hearing on which Judge Chutkan will issue her ruling on the immunity issue before we go to the polls on November 5th. And even if it is not a consideration for Judge Chutkan, it coincides with the election in reality. So, in a way, Donald Trump could not, despite all of the delays that he has employed, able to hide the truth from the American people, even by way of this immunity hearing, that why are these instances not immune? Who and the evidence that is necessary to back that will be presented to the American people during this month of September and October. And that was one of the big asks and hopes that I had that our judiciary would be able to accomplish, not by, and it didn't happen because the judiciary bent, it's because Donald Trump forced. And Donald Trump kept on delaying. Donald Trump could have resolved, this case could have been resolved months ago, but Donald Trump realizes that he's going to lose it. And that's why he's delaying. And we see here that there's a chance still for the American people to be reminded of the truth. And it's an encouraging move towards justice. With that said, thank you so much for being here. Please like and subscribe and share. It really helps me out. It gets my word out more, and it supports my channel. So thank you so much, and I will talk to you soon.